Are you ready? Back on the record in State of Michigan versus Sean Ripke.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Mr. Ripke, can you state your name again?
Sean Ripke.
Okay. And we are here today for
we discussed how she hasn't provided me with any pre-observation report, any pre-conclusion report, and I haven't seen anything in writing. And she said that she had given those things to Mr. Brown, but he hasn't shared them with me. And I also haven't sent probation anything or contacted them at all in any way.
So, Mr. Ripke, I'm a little bit confused because the last time we were here and there was a probationary recommendation and you had counsel or you allowed counsel to help you, you indicated that you wanted to have.
No, I didn't. It's
Mr.
on the record.
Ripke,
it's on the
I'm speaking.
record
Mr. Ripke, remember when I'm speaking, you're not. You indicated that you wanted to be sentenced to a year in jail. You have sent multiple emails and to multiple people in the county indicating that you want a year in jail, and that is probation's recommendation.
That's absolutely not true. That's absolutely not true. And I would love for you to put those emails on the record, because that is not what I said. Now I did say that.
We can't hear you, Mr. Ripke. Can you speak up?
But I did not say I'd like a year in jail. Frankly, I'd like the 9 days I've served time credit due for the full sentence with the $125 fine and maybe some.
Well, that's not going to happen, Mr. Ripke. That's not going to happen, Mr. Ripke.
Okay, and that is because we've made a sentencing agreement.
No, I'm not making an agreement with anyone.
Well,
I'm telling you, that's not going to happen.
I haven't seen a written plea agreement either, though that was my understanding.
There wasn't a written plea agreement. We did it orally in court, in person at the 14A4 district court. You were there.
No, we didn't. No, we didn't.
Yes, we did, Mr. Ripke.
I agreed to.
It was on August 9th,
I would have made sure that the sentencing agreement was attached to the plea agreement.
Mr. Ripke, it was on August 9th, 2022 at the 14A4 district court.
Well,
you were then sentenced. You're sentenced, Mr. Ripke, let me finish. You were then ordered to report for sentencing, and a pre-sentence investigation was ordered, and you disappeared, and we had to issue a bench warrant. And then we've been adjourning this out over and over again for one issue or another.
Yeah, this is really dragging on my life. You know, for the recommendation of $125 in fines and costs, that seems very dismal to reflect 365 days. You know, servitude to the state.
Mr. Ripke, are you ready to proceed to sentencing?
I don't think it's appropriate to move to sentencing. I think that I think that there's been third-party intervention on my case file, and I sent it to my attorney. I sent the proof on a postcard to my attorney. I think that JavaScript.
I'm not sure what you're referring to, Mr. Ripke.
Mr. Brown, is he there? My standby counsel?
He is.
Yes, Mr. Brown, those emails that I sent you of the postcards of the JavaScript of the third-party intervener, the litigation informed these postcards that I sent you, could you please present those to the judge?
Mr. Brown, I'm not sure what he's referring to.
Neither am I.
Your Honor, if I may.
Yes.
I believe that was the email that was sent this morning that I forwarded on to Mrs. Strowski. It was sent to, let me see, I believe it was sent to the prosecutor, as well as it was sent to the 14A3 District Court, Mr. Brown, Karen Barner, the prosecutor, Laura Yagi, Mrs. Strowski, and APA Willenbring. And it was sent today at 12:24 p.m.
That's correct.
What is it?
Well, it outlines third-party intervention on my case file on your guys' behalf.
I'm sorry, Mr. Ripke, I don't understand what that is and what that has to do with whether we're proceeding
Yeah,
to
the
sentencing.
JavaScript sheet, there's, hold on just one moment here. My phone's operating. One moment. Yeah. All right, so this is a request for inspection. Well, that's the.
Lindsay, can I have
There it
signing
is.
dates?
It says defending litigator self-represented Sean Ripke, born July 17, 1995, address 3016 Grant Lane, Midland, Michigan, and online at ripkjsean@gmail.com submits this letter to request a status conference regarding the above reference case. Based on conversations with the prosecuting counsel, plaintiff understands that defendant Sean Ripke believes the status conference would be helpful as shared in raising concerns regarding the Faretta rights and ex parte communication. As well believe these cards recorded are information exchanged by the mode of WebSocket and are bidirectional, meaning the server pushed information to the client, which does not allow direct HTTP. This is evident by the anonymous invoke filters and the absent handle method adapter method assessor for internal reflection of the
So,
obvious
Mr.
invokers are on my
Ripke,
file.
I'm not, Mr. Ripke,
Hence, the
Mr.
no point of
Ripke,
this being made an obvious
Mr.
issue.
Ripke,
Your local administrative order.
Mr. Ripke, you're muted. Mr. Ripke, you don't need to read, I don't know what that is, or I don't understand what you were trying to read into the record, but we're not going to do that right now. You'll need to unmute yourself in order for us to hear you. Mr. Ripke, we need to proceed to sentencing.
I've provided the proof that that my case log has been intervened by a third party.
I don't know what that means, Mr. Ripke. Mr. Ripke, I don't know what that means.
That's not necessarily, it's not my
Mr.
fault that you
Ripke,
don't understand.
what I'm going to do, Mr. Ripke, I'm going to adjourn your sentencing date. I'll give you two options. You can,
Good.
You're going to have to show up in
I just need a little bit more time to hire a lawyer. I'm almost there.
Mr. Ripke, we've been down that road. It's been 2 years now.
No. I just went out and
Mr. Ripke.
the trees are
Mr.
coming to the
Ripke,
ground.
it's my turn to talk. Mr. Ripke, it's my turn to talk. I'm going to adjourn this to June 22nd, 2023 at 8:30 a.m. That is going to be at the 14A4 District Court in Saline. That is going to be an in-person hearing.
All right, I'll bring my own defense attorney. You'll see me there represented.
I'm going to set that for sentencing. I'm sorry. What time do we start that day? Is that 9? I apologize. That's actually going to be at 9 a.m. That will be at the 14A4 District Court in Saline.
Okay, I'll prepare my motion.
You currently have a warrant out for your arrest, Mr. Ripke, for failing to appear to your drug test. No, I'd like you to actually do something you're supposed to do on bond.
Well, I'm
like report for your drug testing.
You drugged me out. You're failing to prosecute me.
And we are adjourned. Thank you, everyone.
Absolutely fantastic. Absolutely fantastic. Oh my God. What up, people? How we doing? Don't know what's up with the microphone. Hold on. Okay. We are good to go. What up, people? How we doing? Oh my God. That was unbelievable. What's up? How we doing? Happy birthday, my crazy. Happy birthday, OG. Hello. Help. All right, there we go. Better? What the hell is wrong? Hello. All right, there we go. Better? Okay. Hello. All right, there we go. Better. Better. Okay. Okay, people. Sorry about that. Don't know what happened. Had a little technical difficulty. I will try to fix it. Okay. I know you guys been going crazy looking for Judge Washington. Some of you have missed it. She cut it. She had a day for the record books, one after another. And guess who made an appearance? Chester Bell! Yes, sir, it was Chester Bell making an appearance. Oh, boy, yes, I will fix the microphone. So just give me a second. So we are going, can't go wrong with Judge Fresh Hour. So I'm just going to do a little something. I'm going to show you something first. I'm going to catch shit for this. I know it, but I don't care. It's my show. This is so funny. Okay, ready? Oh, boy. Here we go. Okay, so here is our show. And then I found an image from my family, my uncle, actually. And he visited a certain cantina. Can you see a resemblance? I'm gonna fix the volume. Just give me a second. All right. As I am trying to fix the mic, I am gonna let this one play for you. The Cantina of Clayton County is coming up. Here we go. Watch this one through, people. This is worth it. Thank you, Tommy.
All right, good morning. This is the Clayton County Magistrate Court. I'm here to let you know what you've been charged with and what your bond amount is if you have a bond set. We're not here to take a plea or have a trial. As you see, there's no one else here today to have any type of hearing except your bond first appearance. So would everybody please raise your right hand that's on the calendar? Do you swear or affirm that any information that you tell the court will be the truth? If so, say I do and lower your hands. Okay, so you have the right to the presumption of innocence, and if you're charged with a felony, you have a right to have your charges indicted by a grand jury. If you're charged with a misdemeanor, you have a right to accusation. You have a right to have a speedy and public jury trial. You have the right to compel witnesses to come and testify on your behalf. And you also have the right to cross-examine witnesses that the state may call to testify against you. And you have the right to have an attorney assist you throughout the entire proceedings. Some of you will be allowed to post what we refer to as unrestricted bonds, meaning that you can go through a bonding company that takes about 15% of the total amount of your bond to release you from custody. So if your bond is $1,000, for example, the bonding company would charge you approximately $150 to secure your release. That's the money that they make for posting the entire bond amount. You can also post the amount directly in cash to the sheriff's department. Example again, if your bond is $1,000 until the conclusion of your case, and it would be returned to you at the end of the case minus some administrative fees. Finally, you can post your bond by using real property. If you have property, it would have to have 3 times the amount of equity in that property to secure your release. So if your bond was $1,000, for example, again, the property would need to have $3,000 worth of equity in order for you to use it to secure your release. Some of you will have what we call a special condition bond, meaning that as a condition of being granted bond, I will ask you not to have contact with a certain person or not to return to a certain location. If you violate the court's order and you have contact with a person or you return to a location that you have been prohibited from contacting or returning to as a condition of being granted bond, your bond could be revoked and you could be charged with aggravated stalking. That's a felony. Felonies are not entitled to bonds, and you could potentially remain in custody until the trial date on your case. If you are charged with a misdemeanor and you do not make your bond, or if you're charged with a felony and do not make your bond, the next time that you would be in court, if you're charged with a misdemeanor, is June the 27th. If you are charged with felonies, the next time you would be in court, if you're unable to make a bond because you don't have one or you can't afford to, the next time you would be in court is on June the 28th. And that court date will be a preliminary hearing court date in which the state would have to prove that there's probable cause that you have committed the crimes as alleged. And probable cause means just what it sounds like. They would literally have to prove that it's probable that you probably committed the crimes as alleged in order for your case to continue in prosecution. All right, so with that being said, we'll get started with the females. The first person that we'll need up is Tawanda Bell. All right, Ms. Bell.
She is, Your Honor.
Oh, okay.
Oh, no, ma'am.
All right, Ms. Bell, you've been charged with simple battery. Your bond is $2,000. Criminal trespass, your bond is $1,000. Obstructing a law enforcement officer, your bond is $1,000. Your total bond is $4,000. You have a special condition that you cannot have.
I can't criminal trespass at my own address because I was at home.
It's up,
It
ma'am.
doesn't matter. I need to let you know that they abuse me.
So the criminal trespass is damaged. Okay, you know what? Don't worry about it. So we're just not gonna get a bond today. Take care, man. Y'all can bring her back. I don't play those games. Take care. All right, Ms. Brown.
Oh, all right. Guys, I apologize for the microphone tonight. I got to fix it. I don't want to get off live. So what I'm going to do is speak real close to the mic, and I will speak as little as possible, and I'm going to let Judge Washington do all the talking because I don't need to speak. It is fantastic. I'm going to let it run. I'm going to shut my big fat Jersey mouth, and I'm going to let you guys enjoy it. I'm going to try to fix it. So let's roll. Thank you all for stopping in. You guys are the best.
As a failure to appear and keep an appointment with the probation department. Did Miss McDuffie place her?
I did.
Okay. All right. So what would your client, let's see. I got to arraign you on the violation of bond conditions, ma'am. It appears that you tested positive for amphetamines on April 26th. And then you missed May 19th, May 26th, and May 30th for testing. You're entitled to have a hearing on these matters, at which time, if it is found that you did in fact violate the terms of your bond could be revoked. And in light of the fact that you also did not report to probation to get the assessment done, it is likely that I'm going to revoke your bond. Ms. Akiri, I can rule?
Yes, Your Honor. I'm sorry, I'm just trying to pull up the information from Ms. Scott Williams. So, Your Honor, I think, I'm not sure, I do understand where we are in regards to the violation, whether or not Ms. Scott Williams would like to plead to the violation. Ms. Scott Williams indicates that she is not inclined to plead to the violation today, but I just wanted to get some clarification. Was the violation already in place on the 5/5 date?
Still low.
I'm sorry, what?
So Ms. Scott Williams
That
indicates
better?
that she went to community corrections to test on May the 5th. But they told her that she could not test or was
She
not.
tested on May 5th. She did EDT and a PBT and it was negative.
Okay. So, Your Honor, what we're going to be asking for, I don't necessarily want to set this for a hearing right now. I know that there's some documentation that we need to get from Ms. Scott Williams. Ms. Scott Williams, will you be able to get us the documentation for your hospital visit, your ER visit?
Yes, I can.
Okay. So I want to just ask for an adjournment, Judge, first, so that we can get that information from her, to see it as brief as an adjournment as the court can possibly give us. We just got this information today that about her whereabouts on the 5/19 date.
Better.
What about 5/26 and 5/30?
May I speak?
Your Honor, the people before she does, Ms. Scott Williams appeared before this court for the final settlement conference that we just had on the 25th, which is in between these dates. So I'm not sure what the hospital visit is going to show, given that. Go ahead.
Okay. Do you have minutes or is everything recorded in the courtroom? Because then I would like for you guys to go back and look and listen. When she got to me, I took it to mean that I was off bond. I didn't have to go to bond anymore. So I didn't go. And I mean, I was found not, or it was dismissed without prejudice or whatever. So why would I continue to go to bond? That doesn't make any sense to me.
One second, Judge.
That's a different case. She had a domestic violence matter that was just a final settlement conference. These are obviously two different cases. So that's what she would be referring to, Mr. Carroll.
Mm-hmm.
And at the end of that final settlement conference, I actually mentioned that we were going to see her back here today for things. So
I just thought all I had to do was show up today.
So, Your Honor, we obviously do not have an explanation other than a misunderstanding in regards to those later missed tests. She states that the 19th test, again, she was in the hospital, so she could show proof of that. And
oh boy,
I'm just not inclined to set this for a hearing at just yet. I know that the court does see these violations as pretty severe, and is looking at potentially revoking her bond. But what I am
Start to drop
asking is
tomorrow.
to have her go and test today as
Start to
soon as
drop
possible.
tomorrow.
Allow us to get the documentation to show proof of why she missed that other date, and see kind of where we are then. I know that it's not going
Better,
to be the
guys?
greatest explanation for the
Is
remaining.
that better?
None of that
yes.
explains why she did not. On May
Better?
1st, she was
Better?
before me.
Still
At that
low.
time, I told her she needed to go get her PSI done. That still has not been done. None of that, even if I were to accept it as true, explains why she didn't get her pre-sentence investigation report done.
And I don't think that we were able to ascertain an explanation from her as to why the PSI has not been completed. Ms. Scott Williams?
I called 5 at 1:32 p.m. I spoke to a younger gentleman. He pulled up my case file. He told me that I did not need to do anything until my domestic violence was settled or whatever. Once I
Better?
was found guilty
Better?
of it or whatever.
Better?
That's
Oh,
what
there
I
we
took it
go.
to mean.
That's
I
better.
did not get his name, but
Hello.
1:32 p.m. May 5th.
You called who, dear?
I
She
called probation.
gone.
And that's exactly what they said. And a matter of fact,
And
I
we're
can tell you.
Miss
back.
McDuffie is gone again.
Oh, boy. All right, give us a second.
There we go, people. All right. All right, first of all, I just have to make a comment real quick. The webcam's going to crap out. I don't care. Real quick, I got to reset my webcam because I checked everything. What's up with that naked guy in the back? All right, I'll shut up. Get back to it.
Okay, she's back.
Physically and mentally cannot handle this. I can't break out.
Ms. Scott Williams?
Miss McDuffie, are you there?
I'm here, Your Honor. I'm sorry. I don't know what these connection issues are today. I am here. And I apologize. I missed what the court said after you mentioned that she hadn't appeared for the PSI. I missed what if there was a ruling after that.
We didn't have a ruling. She's crying and upset, and I'm going to adjourn this to June 26, 2023 at 10 a.m. in person for sentencing and bond violation. Any witnesses can be present on Zoom if needed.
Okay, and Your Honor, you probably have already done this, and there was no reason to be confused about this before, but can it be made extremely clear that Williams, she is still on bond and still responsible for testing even up to that time?
Certainly. She'll be referred to community correction for testing must within 24 hours.
Okay.
What I don't understand is how she could say she's dismissed, but then be here at the same time today. That doesn't make any sense to me.
That's what you told me, your judge. Please look at your minutes, please.
I have minutes, ma'am. They're not called a recording, and it was a different case. And you knew
Because
you
I
were.
don't understand. I asked for everything, y'all.
I'm sorry. what?
Miss Scott Williams, the judge has given us the next date for you to appear. That's June 26th. We need you to be in person at the courthouse. I'm gonna give you a call so that we can get all that documentation together to present to the court then, okay?
You guys didn't even have it right the first. I mean, you guys so.
Ms. Scott Williams, you are very aware that you had two separate cases. You have operating while intoxicated and a domestic
I
violence.
didn't know that I was on bond on the other one. I had no idea.
You're always on bond
really
in
did
every
it.
case. Yes. State of Michigan versus Chester Bell, case number 22S00951.
Rachel McDuffie for the people.
Assistant Public Defender Chinazi Kyriakin on behalf of Mr. Chester Bell. Mr. Bell, can you state your name for the record, please?
Can you hear me? Can you hear me?
Yes.
Yes.
Mr. Bell,
Oh.
state your name for the record, please.
Yes, ma'am. Chester Bell. Good morning.
Sir, first of all, you need to turn on your screen. Secondly, you need to get some of the background noise out from your background.
I'm sorry, Your Honor. I always have problems with this app. Let me try to.
It's not a problem with the app. It's the fact that you're in a place where there's a whole bunch of background noise.
Well, the noise should be gone. The only thing around me is a fan.
What?
Is that too? Oh, wait. Oh, okay, perfect. Okay.
All right.
We love
Sorry, Your
Mr.
Honor.
Bell.
Apologize for that.
We're supposed to be here for sentencing, but Mr. Bell did not make and keep an appointment with the assessor. In fact, apparently gave the assessor a hard time when the assessor called.
Thank you,
Your Honor,
Mark.
I would like to argue against that. I immediately, the lady was making threats and then she hung up on me. I was trying to immediately rectify the problem. She hung up on me. I immediately called my probation officer, Mr. Casey, and then I immediately found a way to get all the way down there, and I spoke with him in person, and he was saying that he was going to leave from there and go and report to you guys. I could explain the situation more in depth if you would like. Do you see that he had mentioned anything about it?
So first of all, Mr. Casey is not your probation agent, that's community corrections agent. And secondly, no, he did not mention anything about it.
That's very unfortunate.
Your Honor.
That's
Yeah.
very unfortunate for me, Your Honor, because
One second,
I immediately.
Mr. Bell, one moment.
So I am just now seeing a report from Mr. Casey. It just says that when he talked to the defendant stated he received a phone call from Von Schwartz for assessment, but it didn't go well. He stated he forgot he had to do the assessment and was confused when they called and started asking questions. He also mentioned that he didn't have the money to complete the assessment. This says the assessment costs $140, but that's not correct.
How much is the assessment, please?
$90.
Ms. Akiri, I can release anything you want to say on behalf of your client.
Your Honor, unfortunately, we do not have good contact with Mr. Bell, so I wasn't able to speak with him to find out what was going on with this particular situation. We would just be asking that the court give Mr. Bell another opportunity, possibly re-refer him to a different, I don't know, I know it's probation who makes a determination of who does the assessment. But if it's possible to connect him with another assessor to allow that assessment to be completed.
I'll leave that up to Ms. Straub as to whether she wants to refer him to a different assessor.
I would be okay with that. I just would like him to know that all of the other assessments will cost more money. Von Schwartz is the cheapest assessment.
What do you want to do, Mr. Bell?
Your Honor, I'm 100% compliant with whatever that you would like me to do. I had forgotten, and then the lady was just making these demands, and I couldn't understand what she was saying, so I was asking her if I could take a couple notes, and she would not repeat herself, and she just kept making threats to me, Your Honor, and that's when she hung up on me. And so if as long as I don't,
Mr. Bell.
I can't. I absolutely can't.
Mr. Bell? You just tried to talk over me and you heard me call your name 3 times. So I don't believe that it's her. I believe it's you. You're still talking.
Always, Mr. Bell.
Please unmute your device. Yes, you got muted because you kept talking over me. I'm debating right now whether or not I should re-refer you, charge you $60, re-refer you, charge you nothing, or just put you in jail so that we can get this done and maybe you'll fully understand the gravity of the situation.
I'm at your mercy, Your Honor.
I love his general manager.
I apologize for speaking over you.
He looks like a general manager at Red Lobster.
My brain is weird.
What? What are you saying?
To re-refer
Oh, he's checking his
for an
hairline.
assessment. My question to you was something you didn't answer. My question to you was simply this: do you want to go back to the individual that called you, or do you want a different person? Anybody else will cost more. Which one do you want?
Your Honor, all I was trying to say was that I don't mind
Sir,
as long as it's not,
answer the question.
as long as it's not with her, Your Honor. I don't care who I'll do. Like I said, I'm at your mercy. I'll do whatever you like. I'm not arguing against the fact that I did anything wrong.
Mr. Bell,
I'm here. I'm
Mr. Bell,
taking
Mr.
responsibility.
Bell,
Sorry.
$60 referral fee. Defendant's sentence will be in person. July 10th, 2023 at 10 a.m.
Could you repeat that, Your Honor?
July 10th, 2023 at 10 a.m.
Where am I going?
You're
To
gonna
report to
come
Von.
You're gonna come in person here for your sentencing on July 10th
Oh, okay. To the main courthouse.
to 14B District Court at 7200 South Huron River Drive, sir.
By the library?
Yes, by the library.
Okay,
Yes,
Your Honor.
Mr. Bell.
All right, thank you, sir.
Your Honor, I apologize for speaking over you. I wasn't trying to be rude at all.
We'll
Yes,
see
you
you here.
definitely were.
Thank you.
You
Okay.
definitely were. We're back. Sound back. There we go.
Said he wanted to
Mark with the membership.
State of Michigan versus Teal Jackson.
Up for all you people that can't stand my voice but watch all my stuff and comment how much I have a big nose and I'm a loud mouth. Well, the volume's back. I'm gonna lower it a little, but the volume's back. You're in trouble. Here we go. Let's roll. Next one. And we all remember with Chester Bell last time. He was flirting with Judge Washington with the Sprite and everything. No, not this time around.
Case number 22S00671.
Rachel McDuff for the people.
Assistant Public Defender Chinazi Carey, I can ruling on behalf of Teal Jackson. Teal, can you state your name for the record?
Thank you, Mark.
Teal Jackson.
Okay, here we go. Now, what are you kidding me? Wait, watch this.
Ms. Jackson, if you are in decent order, please turn on your screen.
Stop, baby.
Thank you, flying monkey.
Your Honor, we
Memberships.
probably need to approach for a few reasons on this matter.
Okay, so far we had a naked guy with someone who thinks she was not guilty, high on meth. Now we have Chester Bell, general manager at Red Lobster, and now we have a woman in a lace tank top with a crying baby. Here we go. Poor Judge Washington.
Thank you.
All right, that's better. There we go. Sound is back. Oh, poor judge. Oh, come on. Up, gotta get that crush. Is she giving that to her kid? The baby drinking that? Oh, come on. Did she really just give the baby Fanta? Is it Fanta or Fanta? We have a big argument in Jersey. People say Fanta. I say Fanta. Fanta. I don't know. Fanta or Fanta? What did she do? Ah, this is grotesque. Yes, you did, Steffi. Look what she's doing. Is she trying to get sexy for Mr. Whiteset? Look. What? If she farts or burps, we're ending the stream. It's over. It's all over. Yeah, Prego. I think so. Oh. You could get off the Zoom. I can't.
22S
Okay, here we go.
003
Oh, nope.
22S
All right, here we go.
00362 state case. Mr. Whitsett has yet to gain his license back so that he could get the benefit of the offer there. And then the show cause case, is that show cause for pay judge, or I wasn't able to?
Let me see.
Now, can I add something?
Oh boy.
The 21 W 61613B is for failure to pay, and the 22 W 1448 is also for failure. 1 second. Failure to pay.
Can I ask a question?
Yes, what is the question, sir?
You said what was what I feel to pay? Will I for to pay something?
Yes, your fines and for your no plate and your expired plate tickets, sir.
Oh, see then that. Oh my. Okay, now what was the show cause? Was the show cause for show cause y'all said? I thought that was for the 8th. Would I have a show cause for something for the day?
Yes, for failure to pay, like I just indicated. Sir.
Oh, sorry. Oh, see, I never knew that.
Oh, learn something new every day.
Okay.
Your Honor, before the people, I just want to clarify. I heard Mr. Kiriakou start off by saying that she wanted to set all of the pretrial matters for a bench trial. If I did understand that correctly, or I think she may have excluded some of his traffic related offenses from that. But I just want to clarify, because the global offer that was previously extended to Mr. Whitsitt from First APA Ganatra was a resolution of he was going to get a reduction of his felony matter to a misdemeanor if he pled as charged in the 3 larceny cases in this court. And we would have been willing to dismiss the driving while license suspended charge and give him a civil infraction to complete that global. So if he wants to set these for trial, he does not have that felony offer anymore, because that's part of the deal. So I just want to be sure that that's clear for everybody.
So y'all was telling me to plead to 3 larcenies and y'all drop a felony?
The offer was to reduce the felony to a misdemeanor use charge, yes.
Oh, no, cause I ain't, yeah, cause I'm saying like,
Hold on, Mr. Whitsitt. You don't need to answer that right now.
Okay.
Judge, I will say that when I spoke with Mr. Whitsitt, I did not extend the offer. I'm trying to find it here.
It's the chain with Mr. Ganatra and Ms. Anderson. I think you were looped in on it. Probably, let's see here. You were in here as of May 16th. The subject matter is PCCs.
Right, I see the email.
Oh, definitely, Peach. Without a doubt, Peach.
Are you gonna need time to speak with Mr. Whitsitt about that?
I will, Judge. I will. I'm trying to, I didn't understand that from the email that that's what the offer was. So we definitely have not been able to discuss that.
All right. I'll put it over for 1 week so you can discuss this with him. Would that be enough?
That would be enough, Judge. Mr. Whitsitt, what?
do I get like a bond or something? I get a right to stay here? I ain't know nothing about the larcenies and at the DV. They said I had. I don't.
What's the DV?
understand.
DMV?
Judge, when I did see Mr. Whitsitt, he inquired about possibility of a bond in this case.
I'm
I
not
did-
addressing bond today. We've done this with Mr. Whitsitt. He failed to show up, even though he was on GPS tether. So, no. We can deal with bond when he comes back here on June 12th, next week at 9 a.m. I mean, yes, 9 a.m.
All right, Mr. Whitsitt, I'm gonna come see you this week so we can talk about the offer, okay?
Okay, well, I mean, like, if the offer is felony, I don't want to do that because I just.
That's not what she said, Mr.
I'm saying,
Whitsitt.
but why
What
would I
up,
take
Charles?
why would I take the trial though? Because I know I'm not guilty of the larcenies. So I'd rather go to
Mr.
trial. I'm not
Whitsitt,
guilty.
I'm gonna come and see you, okay?
Okay, that put out longer though. I might as well set the bond. I mean, the trial thing that put out longer. I'm not guilty of the larcenies.
Mr. Whitsitt.
The larcenist.
All right.
June 12th at 9 a.m. We'll see you then, Mr. Whitsitt.
Oh, bravo.
Ability to sort of get any.
Okay, so now I got something great. We haven't had him on in a while, but he had it great today. Hope you're feeling better, Charles. How about a little Judge Merge? I'm not even gonna say it. I'm not even gonna say it. Here we go.
Problems and just trying to get it fixed to
Oh
get here
boy.
because it's kind of been a hectic morning. Like 20, leaving.
Hold on
We
one
asked
second.
Crystal
Here it
Demetrius
comes.
Richardson. We
Wait,
took care of
wait. I am gonna get it. Here we go. Let's
the courtroom that makes more than $450 a week or $11 an hour. All right.
hold on one second. Let me get this. Get this for you. Hold on. All right, here we go. We all know who this is. We haven't had him, and boy, he had it rough today. Oh boy.
Ma'am, in the tank
Okay.
top, if you'll come on up.
So there's someone in the back of the court, and people in the court are signaling to the judge. And the judge is saying, all right, we got to see what's going on. He calls her up. This is where we are.
Yes, ma'am. You in the leopard skin. Come on up, please.
We already know it's going to be bad because she's in court with a leopard skin tank top. Before we even see her, we know what this is going to be.
Come on up, ma'am.
Oh boy. Woo-hoo, doggy.
You're distracting me with all your head movements. Are you? I know you
I'm on ADHD and I haven't made it back to my house from staying with my mom to make it to court.
She's on ADHD. She doesn't have ADHD. She's on ADHD.
To take my medication yet.
It could be a medical issue, or it could be some other kind of drugs. You're on any kind of illegal substances, are you?
No, my medication. I haven't
Someone in the
taken my
back
meds.
shaking their head yes that you are on illegal
Judge Wade
drugs.
Mercer,
Huh?
Monica.
Yeah. Are you on any kind of drugs today?
No,
So if I
sir.
give you a drug test, you're going to pass it? Is
Yes,
that right?
sir. I ain't done no drugs. I smoke weed, but I ain't smoked that in a couple
What's your
of days.
name, ma'am?
Stelly.
What's your last name?
Stelly.
Stelly?
Yes, sir. I ain't even. I
And
just
you're
got
on
up.
bond, is that right?
Yes, sir. And we were supposed to resolve it because it was actually false accusation.
The
and
state's
all
offers
that.
30 days in jail, Miss Stelly.
Yeah, I was
Is that right,
already
Miss
in
Shellcutt?
jail.
For how long?
3 weeks,
Got 21 days of jail credit.
21 days.
21 days. She bonded out to go to the mental hospital. She's been in the
Exactly
mental
what I did.
hospital,
Okay.
I think until just.
I don't
the
think I
last-
can drug test her against her will. I can't force you to take a drug test. You're not on bond that allows
Yeah.
drug tests, and you're not on conditional release.
Like I said,
Shellcutt.
like he said, I went to go get my mental meds.
Let me finish just a
Okay.
second, okay? The state's offer is 30 days in jail.
Yes, Your
If she takes and passes a drug test, the state have a problem with time served.
Time
So
served.
you can take and pass a drug test if you wish voluntarily, and if you pass it, the offer is going to be time served. If you
Okay.
fail it,
I mean, I know it's gonna pop dirty for marijuana.
is that all?
That should be all.
I know it
mean,
should be,
It
but
should
I've
be
got my
because that's
doubts.
all.
She told the judge she knows nothing about drugs, but she literally said pop dirty. If someone asked me to take a urine screen, and I've had my problems in the past, we all know that, I still wouldn't say pop dirty. There's no way she's not high AF.
I smoke because I'm trying to
So
get my medical
If it's
card.
positive for marijuana, that's not going to affect it being a time served offer. If you
Okay.
have meth in your system
Oh, no.
or any other substance like Molly,
Oh, no.
then that is going to affect the offer.
As far as I know, I shouldn't.
You keep saying as far as I know. If you ask me,
I put it like
if you
this
listen
because
to me, listen, stop.
Go ahead.
If you ask me, are you going to test positive for meth? I'm going to say,
No.
heck no. It's not. It should be. I'm going to tell you no. Why? Because I hadn't taken any meth. So let me ask you again.
Well, no.
Let me ask you again. Are you
Okay.
going to test positive for anything other than marijuana?
No.
Okay. Do you want to voluntarily take a drug test? It's up to you.
I mean, I will.
Okay.
If you
fail
fail
it, if you fail it, if you fail it, I'm not going to accept the 30-day offer. It's going to be more than that. If you
Oh.
pass it, you're going to be time served. You're going to be out of here.
Well, I mean, I should.
I'm not going to accept the 30-day offer. If you fail it, I'm not going to accept the 30-day offer. It's going to be more than that. If you
Oh.
pass it, you're going to be time served. You're going to be out of here.
Well, I mean, I should.
I'm not going to accept the 30-day offer. Just have a seat back in the
Judge, my only
audience.
concern is she takes all kind of medications. Some of them are
That's right.
ADH medications.
She got a
which will-
prescription for meth, then that's fine. But I don't think that's the case.
Yes. He said if she has the prescription for meth, that's okay.
If she's not going to take a drug test, I'm going to assume there's a reason she won't take it.
I was just saying the ADH medications do.
Not for
cause-
meth. Amphetamines, maybe. And if you have some
Yeah, I
research
just-
that shows me that, I'd be glad to see it.
Oh, absolutely. Yeah,
But I see 100 meth cases a month, and they behave in the same manner she's behaving. Now, there are other reasons, Mr. McDaniel. I'm with
not-
you.
I'm not objecting. I'm not disagreeing with what you're saying. I'm just saying that if she's on ADH medications, it will show positive.
For amphetamine. So, but she don't want to take one, that's okay. That's probably a safe thing to do, ma'am, is not take one, but I'm not going to take a 30-day offer with her behavior. So, ma'am, I need you to behave. And if you can't behave, we'll let you wait outside until your case is called. But it's very distracting to see you doing all this stuff while I'm trying to have court. Okay. Okay. So, anybody else on this side of the courtroom that makes more than $400 a week or $450 a week?
Oh, bravo, Judge. Bravo. Bravo, Judge Mercer. I wish he had more cases because then we'd have him on more. But I'm surprised he doesn't get more meth heads. Well, at least like her. All right, here we go. We are going back to the well, Judge Washington. You saw all the craziness, but this one started it all off. So I'm coming back to her. She started the day. Oh my God.
State of Michigan versus Tarika Jackson, case number 18S00335.
So
Rachel McDuffie for the people.
Assistant Public Defender Shanazi Carey, I can really on behalf of Tarika Jackson, Your
where is
Honor.
she?
Tarika Jackson, can you unmute and state your name for the record, please?
Where could she be? Here she. Where is she?
Mr. Geitz, we'll see you next time, sir. You're all set. Tarika Jackson, please unmute, turn on your device and state your name.
Okay. Look at her. So her Zoom profile is a picture of her profile. That's her. So look at her whirly birding around in the top. I'll go back. Look. So Tarika Jackson's picture is going to do the talking for her today.
All right, we're gonna put her in the breakout room.
That
Apparently it's
doesn't
not
look
working
like
very
you.
well.
This looks like a crisscross video from the 90s. Jump, jump. Tarika Jackson, make it. Jump, jump. I can't. It's so bad.
All right, could you try to unmute again?
Hello?
Yes, we can hear you this time.
Okay.
Please state your name.
Erica Jackson.
Erica, thank you, ma'am.
Okay, so Judge, Assistant Public Defender Shanazi Carey, I can really, we are asking for an adjournment. We identified a conflict in this case, so our office will be conflicting off, but we haven't been able to get the paperwork over to the court yet.
All right. All right, ma'am, do you understand what's happening?
Yes, I do. But am I allowed to say something?
It depends on what that is.
I just wanted to say that this case is pretty old, and the defendant in this case is someone I was with for 10 years.
Ms. Jackson?
No, I'm not pleading guilty here. I'm just trying to tell you.
Can't tell me anything about the details of the case, ma'am.
Your Honor,
I mean, she's in jail and.
we know. Your Honor, there's a bond violation on this case as well. This case is accurate. This case is pretty old. It was authorized in 2018, arraignment in 21, several bench warrants since that time, which I think explains why the case is actually this old. So I just wasn't sure if the court was going to address the testing issue today or when the new counsel was appointed.
Okay.
I didn't catch the question, Judge.
Erica Jackson, she wants to know whether I'm going to address the testing issue, which I need to get the report for.
So I have.
I'm not ready.
Ma'am?
Yes.
This case is old because in January, it got authorized way back in April of 2018. You missed 4 arraignments, and then a bench warrant was issued, so a total of 5. And
okay. When this case,
I'm still talking. We can't
okay,
both
ma'am.
at the same time. And then another bench warrant was issued because after that arraignment, you got arraigned, but then you failed to show.
She gone.
on November the 30th. And so then another bench warrant was issued and you got arraigned again. And then you failed to show in December. Another bench warrant was issued and you got arraigned again. And then you failed to show that time. Another bench warrant was issued in February of 2023. So this is actually the first time you appeared before me on this case.
Yes, ma'am.
Now, what would you like to say?
I would like to say, when I missed my first appearance in 2018, my oldest daughter committed suicide. So I was pretty out of it for a while, like a few years, but I was trying to get things together. Fast forward, I just been, I had a couple kids, I've been homeless, I'm just now getting my stuff together. But I heard you say something about testing.
That was like the trifecta of excuses. Fred committed suicide, had a couple kids, homeless. Wow. Wow.
I'm already taking care of something at 15th District, Ann Arbor, as well as somewhere else out there. And I live all the way in Dearborn Heights, and I just think that would be like too much back and forth if you can like just go off of what I'm doing with the 15th District as far as the testing goes or something like that. That would be helpful.
Miss
I don't want to keep missing it and missing tests. I can't afford to go to jail. I just had 2 babies. So
McDuffie, we don't have the report. You may need.
Okay, I'm sorry. I can send it to the court right now, Your Honor. It just says that she failed to report for testing after being released from custody, but I can send it right.
Back when?
You were referred to community corrections by the magistrate when you were arraigned on May 17th of 2023, and you failed to report to community corrections.
Oh yeah. Sorry. That's because I thought that I was gonna have to drive downtown at 15th District. I went there on the 30th for a PSI. I was trying to do everything at once since I was in that area.
You should probably not make any admissions right now.
I mean, I'm just being honest. I've been going through this too
Jackson, the
long.
judge is advising you because you have an open case.
I understand.
Welcome, Basement Gardener.
I just haven't been to jail in 8 years. It's just gonna be too overwhelming for me to go back and forth to Ann Arbor. And I know it's just too much.
Why should we feel bad? She hasn't appeared. She hasn't done anything asked of her. She comes here with her profile picture, can't even get on Zoom for more than 3 seconds to show her face. Probably high. And then we have to feel bad for her because it's too much. It's made to be too much. That's the design of it. So you don't do it again. Oh. I didn't see the end. Judge Washington better not fold.
Miss Johnson here this morning.
Right. You need a cigarette on my plate. Where you gonna go?
What?
Yeah.
Here, so. Miss Stroud.
All right, Your Honor.
Oh, you're here. Miss Johnson, can you check with community corrections to see if she's testing with them for someone else?
I can do that for you, Your Honor.
Thank you.
No, I'm not testing. I have an open case that I'm like same as this bench warrant type thing I'm taking care of. So I'm going back and forth to the 15th District and Ann Arbor police getting fingerprints. If I can do it all in one day, like on my next court date out there, that would be helpful. But no, I'm not testing for anyone.
All right.
She's not even about to press charges like we reconciled 5 years ago.
Miss Ikuria, I can really. You need to speak with their client about the requirement that she test. I don't mind placing it somewhere closer to her, but she's gonna have to test. And her failing to test is a violation of her bond, and the bond can be revoked.
Okay.
Should I put it in the breakout room with someone else?
Yes, Judge, please. You can put her in with Mr. Hawthorne.
I'll pass this now.
Thank you, Your Honor.
I want to say something too. Let's get away from this for a second. There's a guy in our chat, David Cam. All I know is that I thought I watched for a long time, and I know a lot of you have. I watched like prehistoric Zune cases, and David Cam was commenting in it. If it's the same David Cam, he was commenting years ago. So talk about OG. It's an honor to have that kind of chatter in my room. Thank you for stopping by. I look at when I watch the old stuff, he's commenting all over the place. If that's the same one. More or less, smash that like button. Help that algorithm. Make sure to watch that new Judge DeSanto video I dropped. Calling my girl an asshole. How dare you? Okay, here we go. We are
That's what we'll
going.
call the cases.
We are going to. I'm gonna go off the radar, off the beaten path. We seen this judge before. Going back to the well, and we have a crier. It is good. Let's roll.
Mr. Radford from the prosecuting attorney's office.
Remember,
This
Judge
is the time and
Nail.
place set for an arraignment in this case. First of all, Ms. Adams, I need to ask you a few questions, okay?
Okay.
Oh boy.
First question, is your true legal name Kylie Marie Adams?
That is my true full name.
Okay. Do you have any difficulty reading, writing, or understanding English?
No, I don't.
Ma'am, you've been charged by way of a prosecuting attorney's information with 2 counts of aggravated battery. If you were found guilty of those crimes, the maximum penalty could be up to 15 years in prison on each count and/or a $5,000 fine. There is a part 2 to your information that's alleging that in committing the crimes of aggravated battery, you used a deadly weapon. Now, if you were found guilty of either one of the aggravated battery charges and having used an enhanced or having used a deadly weapon in the commission of a crime, that enhances the penalty by an additional 15 years. Now, have you had a chance to review those informations with your attorney, Mr. Cotton?
No, I haven't.
Would you like me to review them with you, or would you waive the reading of them?
Waive the reading, please.
Okay. All right. Now, you also reviewed and signed a notification of rights form.
Welcome, Nelly.
That was way back in December, explaining to you what your constitutional rights are. Do you remember that?
No,
Okay. Have you had a discussion with Mr. Cotton about your
I
constitution?
haven't talked to Colin about it, no.
Okay. What about Mr. Andrew?
I think Andrew I did, but
Okay. Do you have questions about your constitutional rights?
no, I'm okay.
Okay. All right. And so, Mr. Cotton, do you want her to enter not guilty pleas at this time?
Yes, Judge.
Ms. Adams, would you be okay if we entered not guilty pleas for you at this time?
Yeah, that'd be great.
Okay, we'll enter not guilty pleas. I'm going to set the matter for trial on October 11th with a pretrial conference on September 25th at 4 p.m. Mr. Cotton, Mr. Andrews filed a motion for a release on her own
What up,
recognizance.
Daylight? I didn't say
think he
hello to you
wanted to come
today.
down
What up,
and
buddy?
argue that.
Yes, Judge,
Mayor.
if we needed to make an argument on the record today, he did file that. He sent me a copy of it. And I knew he wanted to argue it, so I guess we'll leave that in the court's discretion on what we want to do moving forward with the motion. I'm not sure where he's at.
Well, Your Honor, just so you're aware, the state does object to that. I spoke to Ms. Lavin. The motion was filed late Friday afternoon. It contains some documents she hasn't had an opportunity to look at. She cited Idaho Criminal Rule 46 sub I sub 2, which requires timely notice to be given to the prosecuting attorney in a motion, particularly motion for bond reduction. She cites ICR 45 sub C and Idaho Code Title 19, Section 2912. She's asking it be continued for a week so that she can review it and determine how she wants to respond to it.
Do we have any idea, Mr.
Bob said he saw Scott out in the hallway, so Bob was gonna go get him.
Or
Wait, Andrew's coming?
Yeah, I am, Mayor.
hang on, Ms. Adams. We're going to get Mr. Andrew here.
Okay.
gentleman behind you raising it there. He might need to talk to you. I don't know. Mr. Andrew, come on up.
Oh boy. He's violent.
So, Mr. Andrew, we're going to take up your motion on police on the cognizance.
I'm in there.
Mr. Bradford's voiced an objection for the untimeliness of the filing of the motion filed on the 2nd. You've been given enough time for the state to be able to respond. I don't necessarily have a problem with that. I think that's appropriate. There's some questions I have for you that would help me so that we could relook at this and reconsider maybe a written objection from them. Part of my questions are this. This residence that she wants to live at 310 Carter Street, number 40. I was looking at the lease and it said something about Kevin. Is that the boyfriend?
That's the boyfriend, Your Honor. Kevin, because she was incarcerated, Kevin went through the process of getting the lease in place, but it's Kylie's lease, not his lease. And
she would only be living there by herself?
If that's what the court orders. I think her intent is to have Kevin live there.
I read the innovative health care concepts, and I'm a little concerned about some of the comments that they made.
I'm scared.
And Your Honor, I'd be prepared to address those. Most of them, it's just Kylie denying that those things occur.
I have denied. Never did. I was off my meds and I was not Kylie. I wasn't myself, and I was thinking things that weren't true, even about her and all kinds of stuff. None of it's true. Now that I'm back on meds.
Mr. Adams, why don't you let Mr. Andrew talk, okay?
Okay.
Okay, I appreciate that. I really need to hear from Mr. Andrew right now, all right? So the other question is supported services. She obviously needs some sort of ongoing supported services. And I don't know, she left that place. What's in place for that?
I think for them, Your Honor, she wanted to be in that program. Her mom removed her from that program. I think her intent would be, they gave her the 30-day notice because she wasn't checking in. Kylie wants to be in that program. She wants to be back.
I didn't know if they would take her back. I just didn't see anything.
My understanding is they will, but our office certainly can reach out and see if they will, in fact, take her back.
That's one thing I need as far as confirmation.
And Judge, I did speak with the representative when this case first came through in December, maybe early January, and she was the one who gave me that report and indicated that they would be going to take her back. But I mean, that was in January, so we could just do a quick confirmation with them to double check. But my understanding is that they would. The only reason why they did give her the notice is because she was unable to attend, and they know why that was.
The other thing I want her to do is, if I consider releasing her, I want her on court services release. I want her testing. And I would waive testing fees because of her indigency. But that's something I would want if that were to happen. Does she have transportation?
I'm gonna get a bike.
I don't think she, at this point, has anybody to transport her. She does.
So that's something that
weekly, it would be by cab.
She would have to get a cab.
So that's something else that we would have to look at as far as what we could do. So those are some things that I have concerns about. What I'd like to do is give you an opportunity to think about that and maybe be able to respond with written confirmation that she has the supported services to be able to go back to. Can she do court services release? I don't know if it's impossible, it's impossible, but I'd like to see what that is. I need some more information about Kevin and whether or not he's an appropriate person for her to be able to associate with. I need an honest opinion from you guys would have exams. And then I want to give Ms. Lavin an opportunity to respond. So I'm going to set it on a Thursday afternoon on June 15th. I've got a busy afternoon, but I think that should give you more than enough time. It's not sitting for a long time. Would that be something you all could do?
If that's the soonest the court can set it, we'll take it.
I think that it really is, and that gives me an opportunity to review everything. And I can look at it in addition. I would ask that, well, let's just do that. We'll just set it for that Thursday afternoon, June 15th, okay?
Yep.
2:30 p.m. And then to get up there, that gives Ms. Lavin plenty of time to respond. And we can look at it, okay?
Okay.
Ms. Adams,
Yeah.
I have to think about some things before I make a decision on your release, okay? So
You can ask me, I'll answer honestly. I'm an honest person.
I just need you to be patient with me and so that Mr. Andrew and Mr. Cotton can provide me with some additional information before I make a decision, all right?
All right, Judge Nass.
All right, I'll have you back here on the 15th of June and I'll make a decision then, okay?
Okay.
All right, that's as far as we go today, folks. I'll see you back here on June 15th, ma'am, okay?
Okay.
All right, thank you.
Thank you.
All right, you can go ahead and be excused now, all right? Mr. Cotton, thank you. Mr. Andrew, thank you.
Is it at the courthouse or is it video court again?
She wants to know if it's at the courthouse or video court again.
We'll do it by video with you again, okay?
By video again?
Yeah,
Okay, thank you.
all right, thank you. Mr. Malik, come on up.
Let me out. All right, people. I'm so glad you stuck with me, even through the audio issues. We're back. Thank you so much. I'll see you tomorrow, live, same bad time, same bad channel. Make sure you check out my girl, Kitchen Court Cases. Make sure you check out Credence and Mikey daily, 2 shows all the time. Make sure you go check out The Way I See It. Mrs. Fields' reaction. Looking at legal stuff. If I forgot anybody else, go to my webpage, to my channel. You'll see everything. You have been a serve.